President of the New York State Bar Association, Glenn Lauke. The First Deputy Chief Administrative Judge of the Unified Court System, Lawrence Marks. The Chief Administrative Judge, A. Gail Prudenti. The Associate Judge of the New York Court of Appeals, Jenny Rivera. The New York State Attorney General, Eric E. Schneiderman. The Chief Judge of the State of New York, Jonathan Littman.
In fact, stay where you are. We're going to do the Pledge of Allegiance. Ready? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Now, everybody can sit. Great to see all of you on Law Day 2015. We couldn't be more delighted to have you with us. Before I give a very brief welcome, and we'll get on with the program, let me introduce to you, first of all, the Court of Appeals of the State of New York, starting with Susan Phillips Reed. Eugene Piggott, Jenny Rivera, Sheila Abdul Salam, and our two newbies, Leslie Stein and Eugene Fahey. The presiding justices of the Appellate Division, Karen Peters, Luis Gonzalez, and Randy Yang. The Chief Administrative Judge, A. Gail Prudenti. The First Deputy Chief Administrative Judge, Lawrence Marks. From the legislature, the Chair of the Judiciary Committee, Helene Weinstein. And the Chair of Ways and Means, none other than Denny Farrell. From all the way out in Westchester County, way far away, the great District Attorney, Janet DiFiore. And while I'm introducing ex-judges, the retired members of the Court of Appeals, Carmen Beauchamp-Saparic, I might add, Judge DiFiore, I still call her Judge DiFiore, and Judge Saparic both head up the Justice Task Force, which is so important to fighting wrongful convictions in our state. Victoria Graffio, who I'll mention a little later in my remarks, and Howard Levine. From the executive branch, Alfonso David. Alfonso, are you here? the counsel to the governor, who I'm sure will be here shortly, Harlan Levy, the first Deputy Chief Attorney General, and Barbara Underwood, the Solicitor General. Glenn Lau-Key, I'll introduce later, the President of the State Bar, but David Miranda, the President-elect, is here. And Seymour James, the immediate past President of the State Bar Association. Helene Barnett, the Chair of the Task Force to Enhance Civil Legal Services in our state. We are so grateful for the fight to cure and end the justice gap in our state. Helene. Patricia Owlett, the Dean of Albany Law School, our home law school. And the last person I'm going to introduce is my wonderful wife, Amy Fiedler-Lippman. Okay, now that we've introduced everybody in the room, let me just say that it is great to be with you on Law Day. The Magna Carta, signed by England's King John in 1215, embraces the ideas that form the foundations of our American democracy. When we celebrate the 800th anniversary of the Magna Carta on Law Day 2015, we also celebrate the ideals of liberty, due process, and justice that are central to the rule of law. And we should keep this very much in mind during today's celebration and now, as we hear the Star-Spangled Banner, Court Officer Sergeant Peter Robinson from the 8th Judicial District.
Oh, say, can you see by the dawn's early light what so proudly we hailed at the twilight's last gleaming, whose broad stripes and bright stars through the perilous fight o'er the ramparts we watched were so gallantly streaming, and the rockets' red glare, the bombs bursting in air, gave proof through the night that our flag was still there. Oh, say, does that star-spangled banner yet wave o'er the land of the free and the home of the brave?
Okay, I'm going to give my Law Day remarks, followed by I'll introduce the Attorney General, and then President Lau-Key, and then I will turn the program over to Judge Prudenti for our awards part of the ceremony. On this Law Day celebration, I am delighted to announce the beginning of a new era in licensing lawyers to meet the challenges of our global world. Beginning with the July 2016 bar exam, New York State will fully adopt the Uniform Bar Exam, or UBE, as its method of testing applicants for admission to practice law. This reform will enormously benefit law school graduates, the legal profession, and the public. New York's carefully considered decision to adopt the UBE is a huge step towards a national uniform bar exam for the entire country. A nationally administered UBE is not only desirable but necessary for the mobile, interconnected society in which we live. Let me explain why we are taking this dramatic step here in New York, the legal center of the United States, if not the world. Once an individual has passed the UBE, the applicant will have a portable score that can be used to gain bar admission in any other UBE state. And particularly now, a portable score for prospective bar applicants is crucial. We live in a world where it is common for lawyers to switch jobs multiple times throughout their careers and relocate to different states. Lawyers with families, particularly those with military spouses or partners, can find themselves needing to relocate unexpectedly. The UBE makes it easier to become licensed and employed in a new jurisdiction. And lawyers who can more easily become licensed in multiple states are a tremendous asset. Many law offices handle cases across state and international borders and operate multiple locations throughout the country. Their clients and their businesses require it, while the legal community has adapted to the reality of multi-jurisdictional and cross-border practice. The licensing process for attorneys in the United States has not. Unlike other professions, the legal profession lacks a common licensing test that is shared among all 50 states, whereas doctors, accountants, and others have had one uniform testing system to obtain a license nationwide for decades. In addition to facilitating mobility in modern-day times, the UBE is also enormously beneficial in addressing some of the economic difficulties that new law graduates face today. Employment prospects for recent graduates are still grim, and more people are choosing to avoid the field of law altogether. Law school enrollment for first-year students has declined 30% in the past 4 years and is at the lowest level since 1973. As prospective lawyers become aware of these conditions, fewer people choose to enter the legal profession. Enrollment in New York law schools has fallen 23% since 2010. People are reluctant to invest in a legal education, despite the great need for affordable and accessible legal services by the poor and people of limited means, because they sense that it is no longer a reliable source of employment in today's economy sufficient to justify the cost of law school. The Uniform Bar Exam addresses so many of these issues. For students who take the bar exam in one state but find a job in another state. In the past, they had to study for, pay for, wait for, and take multiple bar exams with uncertain results. With New York's adoption of the UBE, New York law graduates will no longer have to duplicate their efforts by taking the bar exam in multiple UBE jurisdictions. Because the candidates are taking the same exam as the applicants in the other UBE states, it doesn't matter if the test was taken in Missouri, Washington, Arizona, or New Hampshire, and vice versa. All UBE jurisdictions recognize that applicants are tested with the same high-quality examination and rely on the UBE scores to demonstrate that applicants have the fundamental knowledge and skills necessary for legal practice. Meanwhile, each state still maintains control over setting the requirements for admission to their individual jurisdiction and the method of evaluating knowledge of local law. Although we lag behind other professions in uniform licensing exams, progress is now being made. In the last 5 years, almost a third of all states 15 in number, have adopted the Uniform Bar Examination. These states so far have been relatively small in the applicants they test for the bar. With its adoption of the UBE, New York will be by far the largest state with the greatest number of bar applicants in the group. Most recently, in 2014, the Board of Law Examiners administered the New York bar exam to more than 15,200 people from across the state, the nation, and the globe, more than any other state in the nation. And once New York goes to the UBE, momentum will follow. We very much expect that New York's adoption of the Uniform Bar Exam will reverberate around the other states, and that the UBE will become the standard throughout the United States. As Chief Judge, I, along with my colleagues on the Court of Appeals, began to consider the UBE last year. The New York State Board of Law Examiners, headed by Diane Bossy and strongly supported by former Senior Associate Judge of the Court of Appeals, Victoria Graffio, who was absolutely instrumental in introducing the UBE to New York, proposed that New York fully adopt the Uniform Bar Exam. The proposal called for careful study and input given its impact on prospective lawyers, law schools, and the profession. We opened the question to public comment and announced an advisory committee, chaired by my colleague on the High Court, Judge Jenny Rivera, to study the proposal and make recommendations. The advisory committee was comprised of law school administrators, including Syracuse's Dean Hannah Arterian, CUNY School of Law's Dean Michelle Anderson, and Fordham's Assistant Dean Nitza Escalera, Chief Administrative Judge A. Gail Prudenti, former presidents of the state, city, and Puerto Rican Bar Associations, Seymour James, Elio Malonis, and David Hernandez, and the chair of the Board of Law Examiners, Diane Bossy. And I can't say enough about the spectacular work that was done by each and every member of the advisory committee. Their fearless leader, Judge Rivera, dedicated so much energy and enthusiasm to this effort. Given her role as a former legal educator, there could not be a more perfect person to lead the committee. Judge Rivera's strong and sterling leadership on this issue has been the critical factor in bringing us to where we are today. I and the Court of Appeals are enormously grateful to her and to the spectacular Diane Bossy, without whom this initiative would never have gotten off the ground or come to a successful conclusion. Thank you both and all the members of the committee. You took time from your busy schedules to organize and attend public hearings throughout the state, review correspondence from law students, attorneys, bar associations, representatives, and law professors from throughout the country, and meticulously consider each and every implication of the proposed change. And we applaud your efforts. After months of intense focus and research, the advisory committee has now issued its comprehensive, thoughtful, and in-depth report to me and the Court of Appeals, which is available today. The Court of Appeals has approved the committee's recommendations, and I am proud to announce that New York has fully adopted the Uniform Bar Exam and all of its components, along with a state-specific licensing requirement effective for the July 2016 New York Bar Exam, a time frame that will give law students, law schools, the profession, and the Board of Law Examiners sufficient time to prepare for this seminal change in the bar admission process. But what exactly is the Uniform Bar Exam, and what will this change mean in concrete terms for New York and all those who seek to be admitted and practice law in our state. The Uniform Bar Exam is developed by the National Conference of Bar Examiners. It consists of 3 parts. The first is the multi-state bar examination, a 200-question multiple-choice test. The second part contains 2 multi-state performance test tasks designed to measure fundamental lawyering skills. And the third part is the multi-state essay examination consisting of 6 essay questions. The Uniform Bar Exam tests on the law of general application, such as is learned by all law students in the course of their legal education. On the other hand, the current New York Bar Exam has 5 essay questions and 50 multiple choice questions prepared by our own State Board of Law Examiners that test applicants' knowledge of New York law given on day 1 of the bar exam. The first day is rounded out with one of the National Conference of Bar Examiners multi-state performance test tasks, the portion that measures lawyering skills, which New York has used for the past 14 years. New York devotes the second day of its bar exam to the 200-question multi-state bar exam. Anyone who has taken New York's exam since 1979 knows that component well, like applicants in virtually every other state in the country. In the future, changes to the New York bar exam through the adoption of the Uniform Bar Exam and the addition of a separate New York online course and test will ensure the integrity of the state's licensing structure. We will continue to devote the second day to the 200-question multi-state bar exam as we have for decades. However, on the first day, the exam will consist of the 6 essays and 2 lawyering skills tasks created by the National Conference of Bar Examiners. Unique distinctions in New York law will not be tested on the 2-day bar exam. While the law tested on the UBE in many ways is consistent with New York law, we still want to ensure that our new lawyers are prepared in every way for the practice of law here in New York, where the legal profession is the gold standard in the country. Important and unique principles of New York law will be covered under the new protocols. While many of the UBE states have taken steps to ensure competence in home state law, either through online testing or educational courses, New York will be unique in requiring education in the form of an online course and an online multiple choice exam. The online course will consist of hours of videotaped lectures on New York specific law, and the online test will be thorough and rigorous. The online test will be offered during the February and July administrations of the bar exam and once in May and December. Applicants may take the online test during the 3rd year of law school, provided that they complete the New York law course, giving students increased flexibility with their schedules. In many ways, the new paradigm will be more comprehensive in testing state-specific knowledge. Under the current bar exam, an applicant does not actually need to show great knowledge of distinctive aspects of New York law at all. A high MBE score can outweigh weaker performance on the New York essays and multiple choice questions and still result in a passing score. In contrast, under the new regime, a test taker must pass the UBE exam, which has some significant overlap with New York law, and complete the New York component, which will cover areas of New York law not encompassed by the UBE. As we move to the UBE, our New York experts will be involved and influential with the National Conference of Bar Examiners. A New Yorker currently serves on the National Conference's board. Law professors and subject matter experts from New York assist in developing and evaluating questions for the exams and will continue to do so. New York's Board of Law Examiners will continue to grade the written components of the UBE, and we should and will have continued voice and influence on the Uniform Bar Exam, with New York coming on board. In addition, the New York component admission requirement will be developed by our State Board of Law Examiners with the assistance of a specifically formed work group consisting of legal academics and scholars well-versed in New York law who will identify New York rules, unique New York rules that should be tested as part of our licensing structure. Finally, the impact of this change on our diverse applicant pool is of great interest to us. To some extent, the committee could answer concerns in this regard based on statistics from New York and from existing UBE states. Analysis of these statistics suggests that there is no reason to suspect a significant decline in passage rates among people of color and all women. However, the committee recommended that the court adopted its recommendation that data be collected and studied once the UB is implemented to determine over a 3-year period whether in fact there are significant and adverse results, and if so, how to address it. With the adoption of the UBE, New York will remain the gold standard of the legal profession, because rather than being insular, we are embracing a broad vision for the future of our profession. New York is New York because of the diversity of job opportunities here, because we are the financial capital of the world, and because we are a hub for culture, development, nonprofits, entrepreneurs, and public interest advocates and litigation. New York is a global destination. With the adoption of the UBE and our commitment to a global profession, people will more than ever want the credential of a license to practice law in New York. And once again, New York will be the change maker, shaping the legal profession nationally, dramatically altering the balance, and leading the way to the adoption across the country of a rational, effective system for ensuring that new lawyers are eminently qualified to join our truly noble legal profession. Thank you so much. Thank you. I note that some more of our friends from the legislature are here. Senator John Flanagan, welcome. Senator Neil Breslin. And a refugee from the Assembly, City Councilman Landsman is here. That is New York City Councilman. Okay, it's now my privilege to introduce to you our spectacular Attorney General, truly a partner in justice for the judiciary and without unequivocally for the Chief Judge. Whether he is speaking on foreclosures, criminal justice, ethics, the Attorney General stands out by his commitment to equal justice and the rule of law. We are so fortunate in New York. In fact, we are the envy of the country in having such a fabulous lawyer general to be the Attorney General in this state. And it is one of the joys of being the Chief Judge to work so closely in the cause of equal justice for all with our really, truly terrific Attorney General, Eric Schneiderman. It's my delight to introduce him to you today.
Thank you. Good afternoon, ladies and gentlemen. I am very, very happy to be here today. I have to leave quickly to speak at the Fallen Officers Memorial, which is taking place right after this, but I am certainly with you in spirit throughout these proceedings and commend everyone who will be a recipient of the awards that will be given out later today. Thanks to Chief Judge Lippman, all of the members of the Court of Appeals. Thank you for your announcement of the Uniform Bar Exam. You are providing national leadership in moving our state forward and our bar forward. And I have to say, we really should take a moment to contemplate the work that Judge Lippman and his team have done over the last number of years. He said New York must be the change maker. Our Chief Judge is the change maker. And from the representation of the indigent to the justice gap to sentencing, protecting debtors, innovation, legal education, we owe you a great debt of gratitude for your work. And I always love being in this company today here, because I get to see lawyers who I've worked with, lawyers who've worked against me, people who've ruled for me, people who've ruled against me, people who've debated on my side, people who've shut me down in debate. So it's great to be here as a part of this great tradition of lawyer advocates pushing the edges and trying to achieve a just result by advocating for their positions. It's good to remember Law Day with all of you. Today, the theme is a celebration of the 800th anniversary of the Magna Carta. I hope you've got these leaflets here, which remind you of, visually remind you of how primitive a document this was, how long ago it was. But the Magna Carta was truly a statement of transformational principles of justice, unlike any that ever came before. And it is relevant today because Magna Carta stands as a critical marker of progress in the long evolution of our system of justice. And as New York's chief law enforcement officer, I want to focus on the significance of the Magna Carta for criminal justice policies today. We have built on its foundation, but we have the need today, I believe, for further comprehensive reforms in this area to embody the basic principles outlined 800 years ago. And 800 years ago, which is a very, very long time, in a field in Runnymede, England, King John put his seal to a hastily assembled peace treaty that was intended to stave off a war between the crown and a rebellious faction of barons by yielding some powers of the king to the aristocracy, devolving power from the strong leader system to the members, is the way they referred to it at the time. Despite embodying many of the prejudices of its day, and the document does include those, the Magna Carta set forth some of the most cherished rights that are now enshrined in our own Constitution and our own laws, from the right to trial by jury, to freedom from unreasonable search and seizure, to the prohibition on cruel and unusual punishment. It was a watershed event in the birth of our criminal justice system and of the principle that society should be ruled by laws and not men. Now, over the last 800 years, we've made a lot of progress towards realizing that ideal. The English Bill of Rights of 1689 barred excessive bail, further made explicit the ban on cruel and unusual punishments. Our own Bill of Rights followed through and pushed the envelope further in 1789. And through the work of abolitionists leading up to the 13th Amendment and the Civil Rights Movement leading up to the Civil Rights Acts of the 1960s, the United States made great strides towards eliminating race as a primary defining factor in the administration of justice. Each of these events, each of these documents, represented a new milestone in our progress towards a fairer, more effective system. But I'm sure that everyone here today agrees that we have more work to do. And I think it's appropriate to look to the Magna Carta and look to the trajectory on which it set us and look to the future and the trajectory we must maintain if we are to continue to be a truly just society for all. Today, we're challenged to deal with issues of race and class in our criminal justice system more honestly and more fully than ever before. As cities across America erupt with protests, with angers, and with pleas for justice, it is time for another transformational moment in our efforts to move forward and to come ever closer to the ideal of a government of laws, not men. Today, we do not have time to consider more than an overview of this challenge, but frankly, an overview is devastating enough. Today, the United States has less than 5% of the world's population, but nearly 25% of its prisoners. It's not because Americans are 5 times as likely to commit serious crimes. It is because we, alone among nations, have chosen to engage in a unique national experiment with mass incarceration. We now lock up 750 out of every 100,000 residents. No other nation comes close. The rate is 148 per 100,000 in the United Kingdom, 78 per 100,000 in Germany, 51 per 100,000 in France, in America 750 out of 100,000. But if you look at the incarceration rate of black men, we incarcerate 4,000 per 100,000. Not anywhere close to any nation in modern history. Certainly nothing close to any democracy in the history of the world. And in my view, ladies and gentlemen, this is a system that cannot stand. As New Yorkers, we have a special reason and obligation to provide leadership for the next great leap forward, which I do believe is coming, in our efforts to reform this system and to take another major step in the tradition of the Magna Carta, of the Bill of Rights, and of the Civil Rights Acts. We have to provide leadership from New York, in New York, for the next leap forward because we can't forget that in 1974, our state embarked on a mission to stop what Governor Nelson Rockefeller called, quote, an invading army of drug addicts. The Rockefeller drug laws were not based on any evidence that they would work, but rather on fear, superstition, and political calculation. These laws, which we enacted and we accepted for decades, were an abject failure by any measure, yet they inspired a host of tough-on-crime policies across the country, so-called tough-on-crime policies, and it retains broad support across the nation for decades. When the Rockefeller laws were enacted, there were less than 300,000 people in all of the prisons and jails in America. A decade ago, we hit 2.5 million. In New York, when I first came to Albany as a state senator in 1999, our prison population had reached an all-time high of over 72,000 prisoners, more than 400% times the number when the Rockefeller drug laws were implemented a few decades earlier. So we have made tremendous progress since then, but ladies and gentlemen, the events of the day challenge us to make even more. And I would urge you that as controversial as the Magna Carta was in its time, there are some things that may seem controversial today that we will look back on and ask ourselves how it took so long to make these fundamental, reasonable, rational changes to make our system more just. I'm proud of the fact that in 2009, after many in this room spent decades working to raise public consciousness, we dismantled the Rockefeller system and replaced it with evidence-based diversion programs. I was the lead sponsor of repeal in the Senate. Senator Breslin and Senator Flanagan will remember this. There was a lot of hostility towards the reforms. I retain to this day a column calling my bill the Drug Dealer Protection Act. But 6 years later, we know the critics have been proven wrong. Recidivism is down. The prison population is down, especially for drug crimes, and crime is down. With this evidence in hand, with similar evidence from other states, it is time now to move forward, and others are moving forward already. Leading voices from across the political spectrum are calling for action in every part of the country. Last November, voters in California passed Proposition 47, which reclassified many nonviolent property crimes and drug crimes from felonies to misdemeanors and made about 10,000 prisoners eligible for resentencing. In February, Illinois Governor Bruce Rauner, a Republican, and there are many Republicans participating in this movement to set our criminal justice on the right track, Governor Rauner convened a commission on criminal justice and sentencing reform with a mandate to drastically reduce the state's prison population. And just last week, and this is not a partisan plug by any way means, but Senator Hillary Clinton gave a speech at Columbia University, unlike any speech a major candidate for president has ever given, explicitly calling for an end to mass incarceration. So this is in the air. The data support it. There's a website called Right on Crime that features prominent conservatives speaking up about the need for us to right our justice system. And ladies and gentlemen, I think New York, as we have led so much in the past, and given our history in this area, has to step up and take the lead again. We need to go beyond tinkering and take more major steps. And to do so, I believe we need to focus on two things that I really want to convey today and leave you with. First, I think it's essential to be clear about our goals. From my point of view, our goals must be to reduce crime and enhance public safety. These are not conservative or liberal goals. They represent the tradition, dating back to the Bill of Rights and the Magna Carta, of a contract by government to protect its citizens and to do so justly. Second, and this in principle sounds easy, in practice it's very hard, we have to be clear about our methodology for evaluating and implementing reforms. I believe we must adhere unrelentingly to the science of evidence-based practices. We need to study what works and follow the data no matter where it leads. So, my colleagues, if the evidence shows that some form of broken windows policing works to make us safer, then liberals need to get over their discomfort with that. And if the evidence shows that frequent use of solitary confinement as a sanction in prisons actually makes us less safe, then conservatives need to get over their discomfort with that. Let's follow the data. We know a lot already. We know that suspending children from school for minor disciplinary infractions not only does not change behavior, but it makes those children a greater risk for entering the criminal justice system when they leave school. And ladies and gentlemen, if our children do enter the criminal justice system before they graduate, the data tells us that we should treat them as children. Our state is only one of two to treat 16 and 17-year-olds as adults in court. This session, let's raise the age of juvenile offenders in New York. Chief Judge Lippman has been a leading sponsor of this reform. And of course, we know that community-based policing builds trust between law enforcement officers and the neighborhoods they serve. We know for a fact that steering first-time drug offenders into effective court-supervised treatment programs produces better outcomes than mandatory minimum sentences. We know that we have a desperate need for alternative programs and ways to treat the mentally ill who now make up a huge portion of our prison population. New York's judiciary has already done great work on sentencing reforms through drug courts, mental health treatment courts, but we need to ensure that we use this experience to replicate these models all over our state and to take these models to the rest of the country. And finally, we have to reduce the massive barriers to reentry, to employment and education that our prison population faces. My office has been working with employers and colleges, pressing them, trying everything we can to ensure that they give a fair shot to those who have paid their debt to society. In too many parts of New York, a criminal record still functions as a scarlet letter that prevents people from reintegrating into society. We must address that as a part of this process. So, ladies and gentlemen, we've come a long way since Governor Rockefeller signed one of the most punitive reform measures in history and triggered a national wave of irrational sentencing laws. I am confident that in New York we're prepared to take the next step, and I'm confident that a decade from now we will look back and be very proud of this moment when we followed the data, adhered to the principles of public safety, were honest with ourselves and honest about our system. And I know that with the judiciary we have here, with the talent we have in the bar, that we can enact the kind of broad reforms that inspired the barons and the lawyers, because they did have, in fact, jurists drafting the Magna Carta 800 years ago, to apply the Magna Carta's principle. One of its great principles was proportionality in punishment, that the level of punishment had to suit the crime and not be based on superstition or some other agenda. Let's go forward and do this together, and let's be very proud of the fact that we were a part of that great tradition of evolution of the greatest system of justice in the history of the world. I thank you, and I thank you all for your collegiality.
Our next speaker is the president of the State Bar, Glenn Lau Keefe, and he really has been a terrific leader of the New York State Bar Association. He is a fighter for access to justice and for all of the things that make our profession noble, for the values of our profession. I can't think of a person who's done more for the well-being of the profession, the legal profession in this state. He is truly a great leader and a wonderful human being, and it's been my delight and honor to be the Chief Judge during the year that Glenn was the President. Thank you, Glenn, for all you've done for our profession and for the judiciary, and we welcome you here today to speak.
Chief Judge Lippman, Attorney General Schneiderman, judges of the Court of Appeals, the presiding justices of the Appellate Division, Chief Administrative Judge Prudenti, honorable judges and public officials, distinguished attorneys and guests. I am pleased and honored to celebrate Law Day with you, and I thank Chief Judge Lippman for inviting me to address you today, and I certainly address you for your thank you for your extraordinary leadership. So thank you. On behalf of the New York State Bar Association, I extend congratulations to the jurists and court employees being honored today. I join the Court of Appeals in thanking you for your service to the people of New York, characterized by tremendous dedication and the spirit of respect. 800 years ago, in a meadow called Runnymede on the banks of the River Thames, King John and a handful of English barons sealed the Magna Carta, a compromise agreement meant to stave off violent rebellion. Much of the charter, its words printed in Latin on a sheet of sheepskin parchment, addressed matters that were provincial and it reflected the norms and prejudices of its times. As a peace treaty, the Magna Carta failed. The original charter lasted only 10 weeks before it was annulled by the Pope. Yet the Magna Carta was reissued with revisions and reconfirmed dozens of times by regents and kings. In the early 17th century, Sir Edward Coke resurrected the charter and interpreted it to stand strongly for the concept of habeas corpus. For generations since, the Magna Carta has endured as a symbol of liberty. No man, no matter how powerful, stands above the rule of law. The powers and privileges of those who govern must be clearly defined and limited. A free man cannot be deprived of life, liberty, or property except by lawful judgment of his equals or by the law of the land. Laws must be reasonable and fairly executed. Punishment for violations of the law must be proportional to the seriousness of the crime. These radical ideas and the very concept that a written document could serve as a government's framework for preserving these liberties have lodged firmly in the minds and in the spirit of the generation of engaged citizens, revolutionaries, who founded our country. Despite the distance of years and miles and the wide expanse of an ocean, its concepts took root on American soil. More than 500 years after the Magna Carta was first written, American colonists seized on its principles to throw off the oppression of the king. They created a U.S. Constitution and Bill of Rights imbued with the concepts of due process and liberty introduced in the Magna Carta. The Magna Carta had become a symbol and a beacon, illuminating a path toward a new form of government. As Supreme Court Justice John Roberts so eloquently put it, the principles in the Magna Carta laid the foundation for the ascent of liberty. As we celebrate its 800th year, can we take for granted that the principles it has come to symbolize will always be strong? Just over 200 years ago, on a ship in Baltimore's harbor, Francis Scott Key wrote the soaring words of our national anthem when he saw the American flag still flying after the city endured the flames and chaos of a 25-hour bombardment by the British. But last week, we witnessed flames of a different sort in the same city, flames that erupted from riots that followed the death of a young black man in police custody. Outside our courtrooms and Capitol buildings, there have been mounting cries of outrage and distrust in our criminal justice system. On the streets of our cities, in tweets and social media posts gone viral, voices are sounding that something is amiss, that reform is needed. This season is a period in our country's history in which the fabric of our nation is being tested. One generation of Americans drafted the framework of our government, liberty under rule of law. It is for each new generation to make these values heard and understood, even felt. 6 weeks ago, U.S. Supreme Court Justices Stephen Breyer and Anthony Kennedy added their voices to the calls for reform. The two justices testified before a House Appropriations Subcommittee that there are serious problems with the criminal justice system. Justice Breyer put it bluntly, in many respects, I think it's broken. They spoke of the overuse of solitary confinement, a punishment, Justice Kennedy said, that literally drives men mad. They criticized mandatory minimum sentences and called for a deep examination of the United States mass incarceration, a system, they said, which is not working and is not humane. For two sitting Supreme Court justices to speak publicly and so directly on their views on issues such as these that come before them is a very uncommon act. For liberty to endure, however, our country demands such uncommon acts. Is it inevitable that the symbol and meaning of the Magna Carta, cast in bronze on the doors of the highest court in our land, will continue to guide us? Are the documents that forged our nation strong enough to continue to steer and protect our country's future? I often wonder whether we do not rest our hopes too much upon constitutions, upon laws, and upon courts. Many will recognize these words as those of Judge Learned Hand. These are false hopes, he continued. Believe me, these are false hopes. Liberty lies in the hearts of men and women. When it dies there, no constitution, no law, no court can even do much to help it. Judge Hand spoke these words to a crowd of more than 1 million, just weeks before the D-Day invasion, when 150,000 American troops landed on the Normandy beaches, willing to risk everything to restore liberty to Europe. Today, we are in danger of the public losing touch with the spirit of liberty, our country's founding values. Just as troubling as the public outcries for the reform of the justice system is the silence of disengagement of so many in our society. Citizens voice outrage, but feel so disempowered, so disconnected, that they do not register to vote, and thus do not participate in shaping our future. Our state's voter participation has been in serious decline for more than a decade. In the past 3 elections, New York State ranked 47th in average voter turnout. Our last presidential election brought only 53% of eligible voters to the polls. Cuts in the humanities and civics education in public schools have left many students with only a superficial and limited understanding about their own government. Increasingly, with an eroding foundation of knowledge, the public sense of the judiciary and of attorneys is pieced together from snippets of sensationalized, often inaccurate television and movie portrayals. At the New York State Bar Association, we are trying to do our part by advocating for a commitment to keep the teaching of civics education strong and meaningful. We will continue to advocate for changes to the state's voting laws to modernize our system and make it easier for people to register and vote. Together with the courts, the state legislature, and the executive, we will continue to advocate for changes in the criminal justice system that will make our system fairer and more efficient and help prevent the tragedy of wrongful convictions. Without continuous and purposeful efforts to re-engage the public, the spirit of liberty that shone so brightly during dawn's early light after the Battle of Baltimore will not survive. One generation drafted a framework of fairness and due process for our country. It is up to each following generation to make these values our country's living reality and to restore and strengthen the public trust in the system of justice. Just as the American colonists watched while England rededicated itself to the Magna Carta's values, the eyes of the world from countries on every continent are watching our country at this moment. We must win the public's support and confidence. It is not an overstatement to say that the strength of our justice system depends on this support and confidence. We need to breathe the knowledge and meaning of our country's founding principles into the streets, the school buildings, and into the forums where people are trying to make themselves heard. There's much we can do, and there is much we must do to ensure that the Magna Carta, as a symbol of liberty under the law, and all that flows from it, continues to guide the course of our country and lives in the spirit of our people. Thank you.
I want to mention Alfonso David, who I mentioned to you before, is here with us. I welcome you, the Governor's Council, to the Court of Appeals today. And now it's my pleasure to turn over the rest of the programs, the award part of our program, to our absolutely fabulous Chief Administrative Judge, who really is at the helm of the court system, who ensures each and every day our focus on justice for the thousands of people, the absolutely hundreds of thousands a year, millions a year, that come through our doors seeking justice. I am so personally grateful to her for her leadership of the court system and for keeping this ship going in the direction we wanted, forward, not backwards. It has been an honor to serve with her, and I'm so delighted to introduce to you my dear friend and colleague, the Chief Administrative Judge, A. Gail Prudenti.
Thank you, my dear friend and our extraordinary Chief Judge of the state of New York. I know the Chief Judge didn't see this gentleman. He's a friend of both of ours. I am serving in the Assembly. Just like to mention Assemblyman Saladino is with us and has been a justice partner for many years. Many of you who know me know that since I've had the job of Chief Administrative Judge, that Law Day is one of those days that's on my calendar. So each and every Law Day, I wake up in the morning and I say to a gentleman who is a lawyer, who I have been married to for almost 36 years, Happy Law Day. And this morning he said to me, Gail, either you have done the job of Chief Administrative Judge too long, or it doesn't make much to make you happy anymore. But Law Day is a happy day for me, and the reason it is because my part of this program marks another beloved Court of Appeals tradition, and that is our annual judicial and non-judicial employee awards ceremony. I will be presenting this year's Judicial Excellence Awards to two exemplary jurists. followed by First Deputy Chief Administrative Judge Lawrence Marks, who will present the prestigious Merit Performance Awards to 4 outstanding non-judicial employees. I wish to thank our entire Unified Court System judges and non-judicial staff across our state, day in and day out, for their diligent efforts and commitment to year-round ability to make sure that justice is delivered to each and every person who comes into our courthouse. I'd like to extend my gratitude, of course, to our Chief Judge Jonathan Lippman, to the judges of the Court of Appeals, who I hold in the highest of regards, to my friends and colleagues, the fabulous presiding justice. But the New York State Attorney General gave a fabulous speech, and he is an incredible individual, Eric Schneiderman, and the New York State Bar Association President, who I have spent hour after hour with this year, Glenn Lauke, for his support of this Law Day Awards program. So our first award, our first Distinguished Jurist Award, goes to Jeanette Ogden. And Jeanette Ogden is noted for her fairness, her integrity, and her unflagging work ethic, fully living up to her motto, lift while you climb. Over the course of her distinguished tenure, she has presided over a specialized domestic violence court and served as both an acting county court judge and an acting family court judge. Despite her very demanding schedule, she has graciously taken on additional judicial assignments throughout the years, also playing a very active role in her community as a mentor and leader. Justice Ogden embodies the highest ideals of public service and judicial leadership. It is our privilege, on behalf of each and every one of us who works in the New York State Unified Court System, to honor her with this year's Judicial Excellence Distinguished Jurist Award. Judge. The next gentleman I have had the absolute privilege of working with for more years than either one of us would like to admit. Justice David Freundlich is a long-standing member of New York's legal community, devoting his distinguished 25-year judicial tenure and the better part of his illustrious public service career to the Suffolk County Family Court. Previously an assistant district attorney in both Brooklyn and later Suffolk County, Justice Freundlich rose through the ranks to become Suffolk County's chief assistant district attorney and is widely esteemed for his legal abilities, his steadfast pursuit of justice, and his humility. Justice Freundlich was named the supervising judge of one of the busiest family courts in the state of New York, the Suffolk County Family Court. He has labored tirelessly, helping institute and refine practices in support of the best interests of children and family in crisis. He also carries an incredible, voluminous caseload, a testament to his remarkable commitment to leadership. He has helped all of his colleagues, whether taking their calendars or taking on difficult cases or being their greatest supporter and advisor. While Justice Freundlich hasn't yet set a date, he has talked to me very frequently about the process that he has started in planning for his retirement. He exemplifies, I call it the platinum standard in judicial service, and his presence on the bench will be greatly missed, as will his friendship and advice. In gratitude, of his invaluable contributions to the New York judiciary, each and every one of us of the New York State Court System are delighted to present him with the 2015 Judicial Excellence Lifetime Achievement Award. At this time, it is my pleasure to turn over the program to the first Deputy Chief Administrative Judge. I happen to refer to him affectionately as number one. First Deputy Chief Administrative Judge Lawrence Marks.
Thank you, Judge Prudenti. And on Law Day, we always take the opportunity to recognize our outstanding non-judicial workforce, which, as we all know, is the backbone of the court system, and without which we could not possibly carry out the important work that we do. And I would also note that in recent years, where we've been operating under some very tight fiscal constraints, we've relied to an even greater degree on our non-judicial employees, and many of whom we've given more and more responsibilities. And I think you'll see examples of that in the 4 people that we're honoring today. So the first award goes to Karen DiBenedetto, who's the Chief Clerk of the Troy City Court, and not the type to shy away from new challenges. Karen DiBenedetto has a winning mix of qualities at her disposal: extensive technical knowledge, superb leadership skills, a tireless work ethic, and an innate desire to make things work better. Serving as Troy City Court Chief Clerk since March 2009, Karen recently acquired a second set of duties as Acting Chief Clerk of Cohoes City Court, keeping both of those very busy courts running smoothly. In addition, she oversaw the Cohoes City Court's successful conversion to the court system's universal case management system, the UCMS system, and she traveled the state to assist other city courts in making the transition to this new system. Karen's level of dedication is extraordinary, as demonstrated by her long list of accomplishments, including her supervision of Troy City Court's conversion to UCMS in 2013, and her participation on numerous committees such as the Unified Court System's Gender Fairness Committee. Karen DiBenedetto regularly goes well above and beyond her required job responsibilities. Her deep commitment and drive are among her many admirable traits. So it is with great pleasure that we honor Karen with a Merit Performance Award for superior work performance. The next award goes to Monica Dingle, who's the Assistant Deputy Chief Clerk, New York City Civil Court, Queens County. Widely regarded for her can-do attitude and exuberant outlook, veteran court employee Monica Dingle works in one of the Unified Court System's busiest courts, with her days hectic to say the least. Monica supervises the Queens County Civil Court's daily operations, including those of its small claims part. While there's no one more serious about getting the job done and done well, she is renowned at the courthouse for her signature smile and personable manner. Monica devotes much of her day to ensuring that unrepresented litigants are provided the highest level of service to assist them in negotiating Queens Civil Court. In fact, her efforts to promote the Unified Court System's do-it-yourself programs and forms were recognized in 2012 when she and her staff received a STAR Award from the statewide Access to Justice program. Monica Dingle's devotion to public service and pride in the court system's vital mission shine through each day motivating those around her to raise the bar ever higher. She's truly an inspirational force, and it is our privilege to honor her with the Merit Performance Award for superior work performance. Okay, the next award goes to Lisa Ganoy, who's the Chief Clerk of Glens Falls City Court. Even with her own formidable workload, Lisa Ganoy is always ready to pinch hit to alleviate staffing shortages and ensure the smooth functioning of the Glens Falls City Court. Recently, the court clerk's office operated with a shortage of clerks. Despite the court's significant caseload and strained resources, Lisa was able to keep morale high, consistently offering the clerk's office staff her support and encouragement. Often working long hours, Lisa adeptly managed the combined demands of the Glens Falls City Court and her hectic family life, including her volunteer work at the local Cub Scouts, where she performs fundraising and other duties. On top of all these responsibilities, she kept up her participation in the court's efforts to educate youngsters, working with the local youth court, among other activities. It's little wonder that colleagues describe her commitment to the Glens Falls City Court as remarkable. Lisa Ganoy is an exemplary court employee, a civic-minded individual whose hard work, patience, and kindness permeate everything she does. We are delighted to acknowledge her many fine attributes with this Merit Performance Award for superior work performance. And last is Gregory Testa, who's an associate court attorney in the New York County Supreme Court civil term. Gregory Testa earns high praise for his many talents and selfless determination, both as an associate court attorney and volunteer coordinator of public outreach programs at the New York County Supreme Court. Greg's keen intellect, superb communication skills, and calm demeanor serve him fittingly in these two demanding roles. Over the years, Greg has overseen a variety of educational programs at the court, helping raise awareness on important topics such as domestic violence, and also working to promote the court's annual Cultural Diversity Fair and other events. From program conception to juggling all the logistics, he is fully hands-on, donning an array of hats. Even with his plate brimming, Greg always makes time to mentor the court's law interns, commemorate coworkers' special occasions, and offer solace to those going through hard times. Somehow, he also managed the time to participate in his local animal shelter's recent fundraiser, contributing to its huge success. Gregory Testa's vast experience is complemented by his graceful manner and empathetic nature. We are fortunate to count Greg among our court family members, and delighted to honor him with this year's Merit Performance Award for outstanding educational efforts. Okay, and with that, I'll now turn the program over to Judge Rivera.
Thank you. Good afternoon. Happy Law Day, all members of the bench, the bar, our Court of Appeals family, and many thanks to our great and wonderful Chief Judge Jonathan Lippman, and as the former chair, now I can say the former chair, of the UBE committee, thank you for your leadership and vision and for letting me be part of that great process. Thank you so much for that. It is now my great pleasure to introduce to you the winners of the 2015 David A. Garfinkel Essay Scholarship Contest, a contest that's run by the Historical Society of the New York Courts, and we thank very much the Garfinkel family for its great generosity in funding and supporting this contest. Contest is for community college students, and it's really a wonderful opportunity for them to get an up-close and personal view not only of our court and the members of the court, but to write something in their own words about a topic of great importance to our society, and always a timely topic. This year's topic was LGBT, the road to equality. How have the New York courts addressed equal human rights for the LGBT community? Before I introduce the awardees, I wanted to quickly introduce awardees who have received an honorable mention. Cameron Vetter from Tompkins Cortland Community College, Melaine Hecker from Hudson Valley Community College, Steve Brewer from Cayuga Community College, Constance Eady from Genesee Community College, Aaron Pacau from Kingsborough Community College, and Queensborough Community College has several people who participated and received an honorable mention, and I want to quickly mention each of them. Farani Kumar, Vidisha Patel, Avram Weiss, Christopher Chang, Diana Benavides, and Brooke Astarita. Congratulations to all of them. And I'd now like to briefly introduce you and call them up one at a time to our three contest winners. First, our grand prize winner, Jessica Cherry, who is majoring in criminal justice at Genesee Community College. She will be transferring to SUNY Brockport in the fall to get her bachelor's degree in criminal justice. The title of her paper was A Look at How New York State Legislation Has Profoundly Impacted LGBT Family Law. And I just want to briefly read from her last closing paragraph. She said, "It is very evident that in New York State there are many different kinds of family. Family is not defined by the gender of two people in a relationship. It is defined by the love that they share. There is no traditional family, as some people might have you think, regarding a man and a woman. The only way that one can define what a traditional family is in 2015 is a family where two people love each other immensely, and if they choose to have kids, they love those kids just as much and treat them well. We can only hope that the states yet to legalize gay marriage and certain adoption rights follow in the footsteps of New York State and all of the other states that have gotten on the right side of history, and they come to learn that love is love." Jessica? The awardee of the State University Prize is Evan Eckfield. And Evan is a graduate of George Washington University. He's currently in a paralegal certificate program at Westchester Community College and completing his certificate anticipated for the spring of 2016. Wanted to read from his essay, which was titled, "Left to the States, Protecting Transgender People from Employment Discrimination." And in his last paragraph, he says, "It is the responsibility of the courts to enforce and interpret the laws and statutes of the federal and state governments. Therefore, if the rights of transgender people are to be protected, then statutes have to be enacted at the state level. New York is on the cusp of making this happen for the transgender community. The state of New York holds a responsibility to give its citizens equal protection under the law, especially in view of a federal statute addressing this disparity or a binding Supreme Court ruling. When the federal government fails to act, it is up to the states to address issues of equality." Evan? last but not least, from the City University of New York, we have Joshua Cruz. He's a business major on the Dean's List at Queens Community College. He plans to transfer to Baruch College and major in finance and political science with an eye to postgraduate studies in law and/or business. The title of his essay is The Empire State and LGBT Criminal Law, Leading the Way to Progress Under Lady Liberty's Rainbow. In his closing paragraph, he says, "Our nation and our Empire State will have a long way to go when it comes to lesbian, gay, bisexual, and transgender rights. We have gone to many extremes to seek equality for every community. We have gone through courts and legislatures and gone through marches, protests, and acts of civil disobedience. We have been through all of this just so that we can open our eyes and stretch out our arms to help our fellow humans, to ensure that we are looked at through the same eyes in the law. We are adjusting laws to changes in public opinion. The scope and interpretation of every man is created equal, keeps growing and being reinterpreted daily, as we see members of our society going without the equal protection of the law, and we act." Joshua? And if you're wondering, as I said, we are very grateful to the Garfinkel family. The envelopes contain a nice hefty check that I hope they will use wisely. Thank you so very much.
Thank you, Judge Rivera, and thank you and congratulations to all of the award winners today. We're going to finish off in the best possible way with asking Sergeant Robinson to come back up and finish the proceedings off.
Oh, beautiful for spacious skies, for amber waves of grain, for purple mountain majesty, above the fruited plains. America, America, God shed his grace on thee, and crown thy good with brotherhood, from sea to shining sea.
Thank you all for being here. Happy Law Day.